Hello and welcome back to Terms and Conditions, the podcast by Conn Maciel Carey, a national labor and employment law firm representing employers nationwide across a broad range of industries. I am Letitia Silas. I am a traditional labor attorney and partner at Conn Maciel Carey. Here on Terms and Conditions, we demystify workplace laws by discussing workplace matters in a grounded and accessible way. We do this to keep you informed as an employer of choice. Be sure to follow us on LinkedIn and subscribe to this podcast on any major platform where you ordinarily get your podcasts, including Apple and Spotify. Today, we are going to discuss what employers need to know about private sector labor law and maintaining positive employee relations. This is a follow-up to our webinar last month, which you can find on our website, conmaciel.com. For this discussion, I am joined by a very special guest, Conn Maciel. Conn is a founding member of the firm and chair of its labor and employment practice group. Welcome, Conn.
Thank you, Letitia. I'm happy to be here.
Can you tell us a little bit more about yourself?
Sure. I am, as you said, a labor lawyer and an employment lawyer. I practiced law for over 20 years here in Washington, D.C., and about 10 years ago founded this firm, Conn Maciel Carey, and it's been a blast. We advise employers of all sizes across the country on a myriad of labor topics and employment topics and making sure that they are staying compliant with the ever-changing landscape of labor and employment law.
Absolutely. So, Conn, you and I recently hosted a webinar on positive employee relations, protected concerted activity, and union organizing. Our focus was informing employers of their rights and responsibilities under the National Labor Relations Act, which is a federal labor law applicable to the private sector. Conn, in your experience, what is something that is commonly misunderstood about federal labor law?
I think that a lot of companies, and I get this question a lot from managers and human resources and in-house counsel, they don't realize that federal labor law applies to every organization in the country, regardless of your size and regardless of whether you're unionized or not. You could be a small company doing, business and never even heard of labor unions in your state, but yet federal labor law under the National Labor Relations Act applies to you. So it's important that managers and supervisors are trained on the do's and don'ts of what they need to understand to comply with federal law.
That is so true. That's been my experience as well. Most employers don't realize that labor law applies to them whether or not they have a union representing their employees. And we are going to dive into some of that in this conversation. So, Conn, many organizations promote positive employee relations. But what does that mean when we are talking about compliance with private sector labor law under the National Labor Relations Act?
Look, private sector labor law and positive labor relations, those go hand in hand. Every company wants to have a culture of their workplace that's unique to them, unique to their business, unique to their workforce. And oftentimes they do really important things in trainings and policies to build up that culture. And some of that culture may very well be, we don't want a union here, or we don't want third-party interference. And that's okay. That's appropriate. But however you explain your workplace culture and how you enforce your workplace culture, ensuring positive relations, you need to understand that you also need to be communicating with your employees in a way that complies with labor law. And in doing so, understanding what your rights and responsibilities are, as well as the employee's rights and responsibilities under federal law.
Absolutely. In my experience, as many of you know here on this show, and as Conn knows, I started my career working for the National Labor Relations Board, which is the federal agency that enforces the law that we're talking about here. And I've also held in-house roles and executive roles within private organizations. And something that I always like to communicate to management is that Dignity and respect are paramount. When I think about positive employee relations and labor law, I think about employees feeling heard, respected, valued by the organization, and as though they are making a contribution to the mission that matters to them. And so when I think about positive employee relations, I think about what that relationship is between employees and management, where employees walk away feeling those things: valued, heard, respected, healthy, cared for, safe in their work environment. And that all will play into labor law, because depending on how employees feel will determine what their conduct is at work that may implicate federal labor law. So let's dive in more, Kara. So much of labor law concerns employee rights to engage in what's called Section 7 activity under the National Labor Relations Act. Can you help us understand what is Section 7 activity under the National Labor Relations Act?
Absolutely. So to demystify this for our podcast watchers, really Section 7 rights, as you hear it, breaks down into three general types of buckets. The big thing is that we're going to talk about, I think, today is really the right of employees to engage in what's called protected concerted activity for their aid and protection and their coworkers' aid and protection. And both protected and concerted are two different elements that we'll talk about. And that's really the big bucket. Also, a big bucket that we'll talk about is the right to organize and join a labor union or even self-organize. We're hearing some of that happening, where there are some new types of unions forming among employees outside of the traditional big unions that everyone kind of knows about and hears about in the news. And then the last one is to really be able to bargain collectively through either, themselves or their own representative in order to understand what their terms and conditions of employment. And that's what you hear a lot of what unions do. Oh, there's collective bargaining negotiations and so is on strike because you can't agree on their wages, or they want higher and better health care. And that, those are the issues. So that's the third bucket of once organized and once determining the right to join a union, then they sit down at the table and bargain collectively through a representative. At that point, the employees really and managers can't really direct deal with their employees. They have to go through their preferred and recognized representative over the workers' terms and conditions of employment. So those are the three major buckets of what Section 7 rights are when we're talking about the National Labor Relations Act.
Kara, with that, why don't we dive right into protected concerted activity for mutual aid and protection? And I just want to clarify that protected concerted activity for mutual aid and protection really means like that's a bunch of legalese, and that's the statutory language. But what it really means is employees acting together concerning their terms and conditions of employment, whether they're acting or discussing or doing something in connection with their terms and conditions of employment. So, Kara, why don't we go through some of the various forms of protected concerted activity?
Yeah, it's important because it's usually one or more employees together, right? That's the concerted part of it, is that they are together talking about things to improve their working conditions. That could be anything from increasing their wages, asking about bonuses, asking about, again, improvements in healthcare or benefits, kind of the common thing you think about when you talk about protected concerted activity in the scope of financial information and benefits. But there's other things too. There could be things like a group of employees go to their manager or their supervisor and say, hey, we're concerned about this issue, or we want this policy to be revised, or hey, we think there might be unsafe working conditions over here and we need you to get us better tools, or we want, improvements in the methods and the way that we work. So it's really a way of employees coming together and asking for changes in the way that they work on a day-to-day basis. I mean, Letitia, you talked about positive employee relations earlier, listen, these employees, they spend a lot of time at work, probably more time every day in the workplace than they do awake at home, during the work week. And so you want to make sure that the workplace is a place that is safe, that they are treated with dignity, they're treated with fairness. And when employees feel that they're not being treated fairly, that's when they're going to come. They're either going to come individually or together. And when they come together as a group, that's really the red flag that HR and managers need to realize that, hey, even in a non-unionized environment, this could be protected activity under federal labor law. And hey, I just listened to that Terms and Conditions podcast. I need to put a pause and think about what I do next.
Absolutely correct. And again, going back to that very, very core point about this being applicable, whether or not the employer has a union representing its employees. So PCA, or protected concerted activity, is when two or more employees are discussing, taking action concerning, or raising concerns with management regarding their terms and conditions of employment, which include their hours and their wages. And they don't only have to be raising it with management, they could also be raising issues with external parties such as government agencies or customers or clients or other types of organizations. Kara, something that I think is often overlooked is that PCA also includes individual employee actions where that individual employee is seeking to initiate or induce group action concerning terms and conditions of employment, where that individual employee may be taking action on issues of common concern within the workplace, meaning it's an issue that is not only of concern to that individual employee, but it is an issue of concern to many people in the organization or many employees in the organization. It also includes an employee, a single employee, bringing a truly group workplace complaint or complaints regarding terms and conditions of employment. Now, none of this requires evidence of a formal authorization of other employees before that individual employee steps up. And we usually see this in contexts where, say, employees get together after work for happy hour. And at the happy hour, they are discussing amongst themselves their dissatisfaction with perhaps an employer policy, or perhaps their performance appraisals, or perhaps their rate of pay. And then following that meeting, even if it's not the next day, suppose it's several days later or a week later, a single employee from that group discussion then goes to management and confronts management on those issues that were discussed at that happy hour. That could very well be, and often is, a logical outgrowth of the protected concerted activity that employees were engaged in when they were outside of work talking about terms and conditions of employment. Kara, have you had any experience with that as well?
I have. And, I think a lot of times your example is a perfect one is the employer might not even know that they all went to happy hour and we're talking about this together. And so while it could be the outgrowth of that collected activity, if the single employee brings it up and doesn't reference that this is an outgrowth, or this comes from a happy hour meeting that all of us were, or many of us, they don't even have to identify who the co-workers were who participated. But bringing it forward absolutely is considered protected activity. Oftentimes, it might even be more of a letter. Like, here is an anonymous letter that I'm presenting to management. And so long as that letter identifies that there are a group of people that similarly agree about this workplace condition that we want to see change, that that is covered by federal labor law. Doesn't have to be signed, as you said. Doesn't have to be evidence of authorization. Doesn't have to be signed by the employees. Doesn't have to be a formal petition. But in today's environment, there's just so many ways that people can communicate outwardly about concerns in the workplace, whether on their own behalf or whether it's on behalf of others. which really makes that analysis a little challenging. If it is the single employee bringing it forward, there's not other context that management can evaluate as to whether it is individual action or is it really concerted action.
Kara, why don't we help our audience by discussing some of the various forms of protected concerted activity? Now, we already know that discussing salaries, bonuses, promotions, and performance appraisals, that is, that's labor relations 101. We know that that employees have a right to discuss those things. So even in this day and age, in 2025, we still sometimes come across policies, or you may see in the news where somebody maintained a policy saying that employees are prohibited from discussing their wages or discussing how much money they make, and that is not lawful. And so I just want to put that out there that, at the very top, at the very minimum here, employees do have that right to discuss their salaries, bonuses, promotions, and performance appraisals.
Yeah, so there's other types as well. And I think what we're starting to see in 2025 is prominently the use of social media, right? So it's not just through direct, conversations, but it's in social media. It's saying, hey, I think my place is unsafe, or I think that my workplace is unsanitary, or I think my workplace, isn't promoting a positive environment, or I've got a manager who is treating employees poorly because of XYZ reason. And so I think that's really, I think, the cutting edge and the trend right now for where we're starting to see these activities really occur. But as you mentioned earlier too, it could be also, protests to customers in board meetings, right? If you see, if you're holding a board meeting in a major city and employees want to prepare a protest or some type of other action in front of board members or, in the public eye, that certainly is also considered protected activity. And as you said, certainly any complaints to a federal agency, any complaint to the EEOC, not only a complaint, but if you have witnesses who participate and help a coworker in that EEOC proceeding, maybe they provide witness testimony, or in a complaint to OSHA, or in a complaint to really any other agency about retaliation, and an employee testifies on behalf. That is also considered protected and concerted activity that you want to be mindful of and not take action against. So, I think one thing, Letitia, you and I talk a lot about, in addition to the social media, is the social justice issues that we're seeing. And that's not going to go away. It's going to, what is trending as social justice issues will change over time, certainly. But no matter what is the flavor of the day, employers need to realize that how employees communicate in the workplace and how they show their support for certain social justice issues could, not always, but could be something that is covered as protected concerted activity.
Absolutely. We are seeing more of that. And I actually think that is the cutting edge, in my view, as long as it's tied to terms and conditions of employment. Now, not all social justice initiatives or protests or sympathies expressed in the workplace are going to be considered protected activity. But if those activities are connected to terms and conditions of employment, then you should be asking yourself the question, or at least engaging with counsel on what this means for your organization. Kara, going back to the social media piece as well, I think that we're seeing more recordings happening in the workplace, whether that's video recording, whether that is photographs, whether it is audio recordings, right? And generally speaking, now there could be some exceptions, but generally speaking, employees have a right to engage in such activity if it is in connection with their terms and conditions of employment. For example, photographing unsafe, hazardous working conditions, recording the commission of an unfair labor practice. Now, of course, when we're talking about audio recordings, we need to be mindful, or they need to be mindful, and everybody needs to know that depending on your jurisdiction, you might have certain wiretapping laws that could be implicated when we're talking about audio recordings. But just know that if employees are walking around photographing or recording video or audio in the workplace, that is something that you really need to be discussing with your HR department, and your HR folks should really be engaging with either your general counsel's office or outside legal counsel to help you successfully monitor or regulate, to help you successfully regulate that type of activity, especially where it poses a risk to your safety and operations.
Absolutely, absolutely. I had a matter for a client last year where, unbeknownst to the employer, this employee was recording just about every conversation he had with his supervisor. So just at the general workday, he must have hidden his phone in the pocket, but there were multiple audio recordings of his conversations with his supervisor. And then this was a manufacturing plant. He also showed up to the work during non-regular business hours for himself and videoed the production floor and what he believed to be unsafe working conditions for what he ultimately believed should be filed with OSHA. So, it's important to have policies, and we can talk about that too, Letitia, but you really understanding that what employees can do, it's very easy in today's environment and technology that's available to people to be able to surreptitiously record without the employer's knowledge.
Yeah, and we've seen this in the social media space with people recording their performance appraisal meetings or recording their terminations when HR is delivering a termination decision to an employee. We have seen that being posted on social media. So just know that protection, generally speaking, now we're talking generalities here. Now, anything, again, this is not legal advice on terms and conditions. We come here to help demystify some of these concepts. But when you are faced with these things in your organization, you really should be engaging counsel to help you better understand what your rights and obligations are as an employer. But yes, that recording piece is really, really popular and key in this environment that we're in. So, Kara, in our webinar, we actually had a hypo on this very topic. And in that hypo, there was an employee who was suspended from work for conduct reasons. And when the employee was placed on suspension, the employee then went on social media and made various statements about the employer's operation. And this was in our hypo, this was I think it was a food manufacturing company. And the employee went on social media, said, hey, these are some things you need to know before you go work at this place. And the employee made various statements about the employer, including alleging that the employer's manufacturing process was unsafe and unsanitary. And so our hypo posed the question of whether or not this could be considered protected concerted activity. What are your thoughts, Kara?
Yeah, this hypo on our webinar spurred a lot of questions from our participants with a lot of Q&As, and it's interesting. One is, first of all, this is just one employee. He's suspended. He's on his own time at home, not during working hours. He's using maybe his personal phone or his personal computer, sitting in his home office, posting on social media, posting on TikTok, posting on YouTube, posting on, who knows what. So he's really doing it on himself. He's not this isn't concerted, right? Because it's not him and a bunch of other people or two or more employees. So the first question is, is that protected, right? Because he's acting on his own. The other thing that is important about this employee is, who is this employee? Is this guy a supervisor? Is he a manager? And when I say supervisor, I mean like a manager, someone who really manages, leads, as part of the leadership team. Or is he an hourly employee, someone who, isn't eligible, doesn't supervise, is eligible for overtime? Who is this employee? And again, what's he doing? What's he saying? The other thing that I think is important to understand that HR, as they're doing this investigation, is, well, is he saying things that are true, right? Like, are these stories, are the working conditions unsafe? Are they unsanitary? If he's posting any pictures on the, or any recordings, is it actually the company's facility? Or is he taking images off of the internet and saying, this is our workplace? Like, important to verify whether, the statements and the images and what he's saying are accurate. But to your point, Letitia, earlier, even though he is acting alone, maybe on his working, personal time, not working time, the fact that he could be talking about things, if true, are issues of common concern, right? They are commonly concerning all employees because they would be unsafe, unsanitary. That could be concerted activity, right? And so it's important to recognize that, okay, the content of what he's saying, even though he's saying it by himself while on suspension, could be concerted if accurate. The other thing to think about too is he posting things that I would be concerned about as an employment lawyer that indicate some kind of private, confidential, proprietary information of the company? Is he now blasting out to the public things that the company intends to keep private, like its machinery, like how it processes certain things, the time of day? All of that could be trade secret. And so that would also be highly concerning as an employer, as to what this employee is doing. So there's a lot of nuances, I think, to this, what seems to be a straightforward, common question, but it really does open the door to whether this could be protected by federal labor law.
I agree, Kara. If I'm looking at this set of facts, the first thing I'm asking myself is this an issue of common concern? And or is this a logical outgrowth of employees' prior protected concerted activity? That's the first thing I'm asking, right? Even though we have the employee who is on suspension, so not on working time, and technically, we wouldn't want people posting on social media during their working time. That's a whole other conversation. But yes, those are the questions I would be asking. Just like you pointed out, Kara, I would be wondering, well, are these statements actually maliciously false? Are these statements really knowingly, this is wrong, this is untrue, false information that you are spreading, rumors that you're spreading about the employer's operation? And I would be concerned, like you said, Kara, about, are we exposing potentially trade secrets? Maybe if this employer in their baking process or their manufacturing process, maybe they have a secret sauce, maybe they have a secret formula, and to have that potentially being videoed and put out to the public could compromise the secrecy and confidentiality that the employer has in that information. And so, again, to your point, when you are confronted with these types of facts, my suggestion is to not have a knee-jerk reaction, but to engage legal counsel so that they can help you better collect all the facts and information that you need and understand what your rights are and what your options are in this space, as well as your obligations. So, Kara, what is not considered protected concerted activity? In other words, what types of conduct would be unprotected conduct under the National Labor Relations Act, even if it is a group of people?
Yeah, I mean, even taking this hypo that we just talked about, I mean, your comment, Letitia, is this maliciously false? Is what this employee is posting, he knows that it's not true, or he's using images that are from a different organization, a different workplace, or from the internet, and yet he's attributing that to the company. That's not protected activity, right? That is wrong. That violates, hopefully, many of your code of conduct, many of your handbook policies, that you can take action on, and it would not be protected. Anything that's not related to terms and conditions of employment. I mean, if he was just posting and venting about other things, not talking about unsanitary conditions or the equipment or whatnot, that would not be protected activity. Because remember what I talked about earlier, one of the things of Section 7 rights is it needs to relate to terms and conditions of employment. That's why your podcast is called Terms and Conditions, because that's really the center focus. And if an employee is ranting and raving about something that is not affecting terms and conditions of employment, that is not protected activity. Certainly, obscene conduct, illegal conduct, really, again, going back to sort of the maliciously untrue, harassing behavior, that kind of information, that's not protected. Also, too, just general slowdowns, general work stoppages. In a non-unionized environment, employees are there to work. And if there's something that happens, even if, like you said, they're collectively doing it together, generally, a work slowdown or a sit-in is not protected concerted activity.
That's absolutely correct. Kara, I also want to point out individual gripes and complaints only affecting that single employee, the remedy for which will only flow to that employee, where there's just someone who is disgruntled and they're just complaining about their own issue, not an issue of common concern, not an issue that is a logical outgrowth of employees' prior protected concerted activity. This employee is just complaining and griping about themselves, right? Everything is a I, and a me, and doesn't at all implicate anyone else or anyone else's sentiments. I would say that is not considered concerted activity. And if it is not concerted activity, it is not protected activity. Kara, I also want to point out that insubordination, generally speaking. So that is really defined as a failure or refusal to follow a legitimate work directive. And so where you have someone who is not following a legitimate or refuses to follow a legitimate work directive, that's insubordination. You talked about strikes or work stoppages and sit-ins. Again, yes, employees have a right to strike. That's protected concerted activity, whether or not they have a union. They're represented by a union. That employees don't need a union to engage in a strike. But a slowdown, right? A sit-in, those are unprotected forms of work stoppages. Kara, I also want to point out hateful social media posts could also fall outside of the protections of the National Labor Relations Act. Is there anything else in this space you think we should discuss?
I think it's really making sure that employees know what the employer's expectations are and what is appropriate and what is inappropriate, and that employers apply those expectations uniformly and fairly. And so if you're going to discipline somebody for the behaviors that they're acting that is not protected in concerted activity, you want to make sure you've disciplined other people if that same conduct has happened before. So it goes back to the integration between labor law and positive employee relations, and in ensuring that employees are feeling that their workplace is a place of fairness and equity and transparency and accountability.
Absolutely. That fairness is definitely key. If employees believe that the rules only apply to some and not all, then that is not going to help your employee relations. If employees believe that the rules are enforced arbitrarily, just whenever you feel like it, they don't know if they're going to come to work and trip a wire and supervisor's going to go off, then that is not going to be helpful to your employee relations dynamic. Employees don't mind rules. That's been my experience. They just want clarity and consistency and fairness in the rules. So, Kara, on that topic of rules, let's get into employee handbooks. Now, we know that the National Labor Relations Board has a standard for evaluating workplace rules, often contained in employee handbooks, to determine whether or not those rules comply with the National Labor Relations Act mandate to not interfere with, coerce, or restrain employees in engaging in protected concerted activity or union activity. So, can you talk about just the importance of evaluating your workplace rules and employee handbooks to ensure compliance with the National Labor Relations Act?
Absolutely. This is an area that we do a lot of work on for our clients and companies, because not only is it important to update your handbook when federal law changes, state law changes. The state just passed a new Paid Sick Leave Act. I have to have a notice requirement. I've got to update my handbook. We get a lot of handbook reviews to say, look, can make sure that this complies with the state law, complies with my city law. States are constantly passing new legislation on an annual basis. Federal law changes, the Supreme Court issues a new ruling, and all of a sudden handbook rules need to be changed. What a lot of employers don't realize as well is they need to look at those policies with the lens of how would the National Labor Relations Board look at these policies, again, to your point, so that these policies are not restraining and unintentionally restraining employees' rights to engage in this type of Section 7 rights or protected concerted activity in the workplace. So it's really important that employers update those handbooks regularly, because the National Labor Relations Board changes their mind all the time on different issues or issues cases that implicate different policies. There was one, a little over a year ago that talked about recordings in the workplace and what is an appropriate or inappropriate recording in the workplace. We're seeing topics about employer provided email, and if you provide employer email access, can that employee use the employer provided email access to engage in protected concerted activity, to talk about union organizing or a lot of the issues we've talked about today. So it really is an employer's first line of defense to have a very strong, compliant handbook, both for positive labor relations, making sure that employees, again, understand their expectations. Here's our code of conduct. Here's the do's and don'ts and what I can and cannot do. It gives the employer the rules that they can enforce fairly and consistently, as we've talked about, and making sure that they have, what they need to take an action that they might want to be taking in response to employee misconduct. But most importantly, that it's regularly reviewed through that lens of, I don't want to create a policy that may be lawful in some state, but is otherwise unlawful because it does intrude on an employee's rights to engage in activity, or otherwise could be viewed as coercive or restraining of their rights. So I can't stress enough, not just being an employment lawyer, but I cannot stress enough how important it is that employers regularly update their handbooks and have it reviewed by competent employment labor counsel. We get a lot of clients who say, hey, I've got this third-party consultant, or hey, I can use my payroll company to review my policies and procedures. But they're not looking at it through the lens, Letitia, that you and I look at it regularly, and they're not looking at it knowing what issues just came out from the board. That's important, because if you have an unlawful policy in your handbook, just a single standalone policy, page 75 in your handbook, that could be considered an unfair labor practice. And the board has brought complaints and issued decisions over a single policy in an entire handbook. So like I said, I can't stress enough the importance of having that reviewed by competent labor counsel.
Absolutely. And if you take action against an employee based on a policy that the board determines is unlawful, then guess what? You have to undo whatever that discipline was. That's one of the remedies, right? And then you have to post a notice about the rule, right? And that you won't interfere with employees' protected activity and so on and so forth. And so to avoid all of that, you want to make sure that you are having your handbook reviewed by, I want to say, employment counsel and separately traditional labor counsel. Why? Because the NLRB says even if a rule is facially neutral, even if on its face it doesn't restrict or coerce or interfere with employees' protected activity, if it could be read by employees as doing such, right, then that rule would be unlawful. So you need to have competent traditional labor counsel who's used to looking at NLRB case law, who's used to understanding the contours and the nuances of this PCA doctrine to be able to issue spot things in your handbook and in your policy. And not only issue spot, you don't want folks who can just come around and spot the issues, but they can't tell you how to fix it. You want people who can identify the issues for you and then give you sound advice for lawful compliance that you can stick to and stand up with, right, if called to challenge. And so if you have those handbooks out there, please be sure that you are having the appropriate professionals. And my suggestion is attorneys at Conn Maciel Carey review your handbook. Okay, so Kara, we talked about handbooks. Why don't we now jump into union activity and how PCA, protected concerted activity for mutual aid and protection, also includes union activity. So union activity is a form of PCA. Let's dive into union activity, starting with first, what are some of the reasons why employees decide that they want to engage in some sort of union activity or forming a union?
I see it a lot of different ways over the last 20 years that I've done this kind of work, Letitia, and it's a misconception that employees unionize because of wages or because of benefits or because of, other things that employers do on a day-to-day basis. That's why we have Title VII. That's why we have the Fair Labor Standards Act, right? We have 40-hour work week. And if you work over 40 hours, you're going to get overtime. There are a myriad of employment laws and federal and state laws that regulate the types of things that workers traditionally maybe did unionize back in the 40s and 50s. But in the year 2025, what I'm seeing is the old adage of unions don't organize employees, poor managers do. And it goes back to what we talked about earlier is if an employee feels that their manager is not listening to them, if their manager isn't treating them fairly, or their manager is taking actions that are arbitrary and capricious, and they've raised that issue to other managers or to human resources, and human resources isn't doing anything about this manager, they're going to go out and seek a union and ask for help from a third party. And time again, when we advise employers that get a union petition on their desk, the first thing I ask is, what's going on with management? Where is the rub? And that often is the key to union organizing. And so when you do hear, in HR, when they do hear of concerns about mismanagement or poor management, you want to be supportive of your management team, but look into that. It's important to understand whether that could be something that is brewing a little bit larger. So that's, I think, off of my head, that's the number one reason that right now in 2025, employees organize.
So I'm going to differ from that just slightly. I've been in-house and I've seen how things play out in an organization. And, there are going to be people who listen to this podcast who say, well, wait a minute. We have some really good supervisors. We have some really good managers. And these managers and supervisors are trying to change the culture, and they are trying to hold people accountable. They are trying to ensure that we are meeting productivity goals. And because maybe we were a little lax in the past, we have this new management team coming in. There's a backlash against this new management team because maybe we weren't so committed to making sure everyone was hitting the targets like we are now, right? So I want to give some benefit of the doubt to organizations and managers who maybe you're just holding people accountable. Maybe you're just saying, you know what, I'm going to have some real goals and some real targets, and this is how we're going to measure our progress in this business. And sometimes that could be uncomfortable for people. And sometimes that could result in complaints about that supervisor or director or manager. And I've seen that happen time and again. I also want to point out, Kara, that what I'm seeing more and more is an ideological stance in terms of unionization, that there are many groups now who just believe that ideologically it is their right to form or join or assist a labor union. And that is a right that they don't want anyone telling them they don't have and that they can't engage in this activity. So for them, it's ideological. I have seen circumstances where the employees, yes, they are well compensated. They have great benefits. There are no real tangible complaints about management, but this is just what they choose to do based on their ideological stance. I've also seen time and again health and safety concerns being a reason why employees decide that they want a union. Maybe it's unsafe work equipment. Maybe it's generally other types of unsafe working conditions. And employees believe that they've brought this to the attention of management. Management hasn't done anything about it. And so the only way that they can get some sort of assistance with this is if they reach externally to the assistance of a labor union. I also want to point out what we talked about earlier is arbitrary application of the rules. If people don't know what the rules are, who's going to be held accountable, then they want to bring in some external help so that they have some sort of consistency. And in 2025, I am also, Kara, seeing that job security is a big deal in a lot of industries. And so if people feel that their work can be contracted out, that AI can do the work, or that they get just limited term appointments or contracts in their employment structure, then that would be a reason why they say they want union representation in hopes of having greater job security.
Absolutely. I couldn't agree more.
All right, so Kara, why don't we dive into we talked about types of protected concerted activity. Now let's talk about what are some forms of union activity? Like, how does union activity manifest? What does that look like?
Yeah, I mean, it can be as simple as, a group of employees getting together on a Sunday at a local pizza joint and talking about issues in the workplace with a union organizer. Sometimes the unions themselves may be targeting a particular workforce without any employee instigation. Maybe it's because the union is targeting a particular industry and they want to represent all the companies in this industry in this city. And so a new workplace comes up and they want to target that company for unionization, regardless of what's happening at the workplace. So we can see it in a variety of different ways. We see it if someone, again, you talked about strikes, regardless of whether someone is unionized or not, we might see strike activity or protest activity because of things that are happening, in the globe or locally or nationally. So I would say it's really comes in a lot of different forms. But most of the time, if it is employee driven or union driven, the employers aren't going to know it's happening. Unions are very savvy about being able to get employees' attention off property, off regular working hours, and really advising them to keep it quiet because of a concern that they don't want the employers to get wind of any organizing activity, because they don't want employers to combat, that messaging, whatever messaging that they're giving to the employees. They want to be able to get all of their kind of ducks in a row, as much employee support as they can, and are legally needed to proceed to the next level, formally filing a union petition with the National Labor Relations Board. So a lot of times what I see is that employers feel that they're caught off guard when they hear about union activity. I can't believe it. Not Mary Jane. She's our best employee. And then all of a sudden, now we're advising our clients on responding to the union petition while also trying to communicate to the employees, while the union has been doing a lot of work over the last few weeks, months, could be even longer. So that's a lot of where I see when employers learn about it, is it's a little bit later in the game, and there's been some solid activity by employees and unions together before it comes to management's attention.
Absolutely. I think that's a great point to leave on. Kara, I'm going to also add to that how organizations respond to employee activity could also be something that is an impetus to union activity. So depending on how an organization responds to employee complaints and concerns being raised, I have heard of cases where employees raise a wage complaint. Supervisor or employer responds poorly to that. And then as a result, employees then go communicate with people in the community about what happened at work. And then somebody in the community says, oh, well, I know the guy over here at this union. Maybe you should talk to that person. Maybe they can help you get some resolution to your wage concerns. So depending on how the organization responds to employee action or concerns could also determine how and when employees decide that they all of a sudden want to enlist the assistance of a labor organization, i.e. a union. And with that, Kara, we are at time. I want to thank you so much for coming and talking to me on Terms and Conditions, the podcast all about demystifying workplace law in a way that is grounded and accessible so employers can be the employer of choice. Thank you so much for your time today.
Thank you, Letitia. I enjoyed being here today.
Absolutely. And until next time, folks, stay ready so you don't have to get